Sophia Castelli. I'm the National Director for Cooperative Programs here at the College of Law, and today I'm going to take you through the nitty-gritty that you need to know before you apply for admission as a lawyer in the Supreme Court of Western Australia. Think all you need to be a lawyer is a law degree? There's actually more to it than that. Specifically, you also need to be admitted as a lawyer and officer of a Supreme Court in Australia. This presentation will take you through the process and requirements for admission as a lawyer in WA. Please note that the content of this presentation is current as at the 20th of July 2021. In Western Australia, the admission process is currently regulated by the Legal Profession Act 2008, the Legal Profession Admission Rules 2009, and the Rules of the Supreme Court 1971. This is likely to change on the 1st of January 2022 as the Legal Profession Uniform Law Application Bill 2020 is currently in Parliament and is likely to commence on that date. The uniform law has been operating in New South Wales and Victoria for some time, and admission requirements will not change to any great extent once the uniform law commences. The admission process involves both the Supreme Court of Western Australia and the Legal Practice Board of Western Australia working in cooperation. Essentially, the Legal Profession Act, sections 26 and 21, allows the full bench of the Supreme Court to admit a person as a lawyer if the court is satisfied that the person has completed an approved academic qualification, i.e. a law degree obtained from an Australian law school, has completed an approved practical legal training course or an articled clerkship, and is a fit and proper person to be admitted. The person is also required to take an oath or affirmation of office. The question of whether or not a person is a fit and proper person to be admitted is determined during the application for admission process. In making its determination, the Supreme Court relies on the advice of the Legal Practice Board and the information contained in the compliance certificate issued by the Legal Practice Board. So why do we need to be fit and proper to be admitted as a lawyer? This is a profession which depends on the conduct of all officers of the court. It's a profession which is held to high standards and necessarily so. Without processes to ensure ethical practice, the legal system could fall into disrepute. The admission process is therefore a very serious and important first step to ensure that the privilege of being admitted to this profession is given the attention that is required. As such, limiting admission to practice to only those suitably qualified persons who are deemed to be fit and proper is in the interests of the administration of justice. When it comes to the question of what it takes to be a fit and proper person, unfortunately, there's no definition of fit and proper person in the Legal Profession Act. In considering whether a person is a fit and proper person to be admitted, the board may take into account any suitability matter. Suitability matters are set out in Section 8 of the Legal Profession Act. The Supreme Court or Legal Practice Board may consider any other matter it considers relevant, as well as anything from the list of relevant matters at Section 38 of the Legal Profession Act. In order for the Legal Practice Board and Supreme Court to make a determination about a person being a fit and proper person for admission, applicants for admission are required to disclose any suitability matters when completing their admission application form. One significant suitability matter that the Legal Practice Board may consider is whether a person is currently of good fame or character. In order to address this issue, you will be required to provide 2 certificates of good fame and character when you complete your admission application form. Let's now look at some of the other suitability issues you may need to disclose. The Legal Practice Board's disclosure guidelines are particularly helpful when determining whether or not something should be disclosed. You can find the disclosure guidelines on the Legal Practice Board's website. The following is an extract from the disclosure guidelines. A person is required to disclose any matter which might be relevant to the board in considering whether the person is currently of good fame and character and is a fit and proper person to be admitted as a lawyer. This will include any of the suitability matters set out in sections 8.1 and 38.2 of the Legal Profession Act that apply to the person. Further, any other matter that might be relevant to a decision by the board or the court about whether the person is a fit and proper person must also be disclosed. Recent cases demonstrate that the courts believe there is an increasing expectation that any matter relevant to the assessment of a person's honesty will be disclosed. Unfortunately, it is not possible to provide an exhaustive list of all matters which can turn out to be relevant to assessing whether a person is currently of good fame and character or a fit and proper person to be admitted, and which therefore need to be disclosed. Stated in general terms, however, the duty of disclosure extends to any matter which reflects negatively on the person's honesty, candour, respect for the law, or ability to meet professional standards. A person should provide a full account of any such matter in the person's disclosure, including a description of the person's conduct. The description should not be limited merely to listing criminal charges or other consequences of the conduct. As already noted, there is an increasing expectation that any matter relevant to assessing a person's honesty will be disclosed. A person should also avoid editing or selecting only those matters which the person believes should be relevant to the question. Rather, a person should disclose every matter that might fairly assist the board or a court in deciding whether the person is a fit and proper person. Revealing more than might strictly be necessary counts in favour of an applicant, especially where the disclosure still carries embarrassment or discomfort. Revealing less than may be necessary distorts the proper assessment of the applicant and may itself show an inappropriate desire to distort by selecting and screening relevant facts." End quote. The Honourable Deborah Mullins, Chief Judge of the Supreme Court of Queensland, further suggests that determining whether an applicant for admission is of good fame and character invites a wide-ranging inquiry. This wide-ranging inquiry should include obvious matters like convictions for dishonesty offences, convictions for other types of criminal offences, guilty pleas to criminal offences that do not result in the recording of convictions, academic misconduct in the course of university studies, bankruptcy or other insolvency, investigations by the Australian Securities and Investment Commission of companies associated with an applicant, any restriction on an applicant's right to engage in legal practice in another jurisdiction, whether an applicant is the subject of a restraining or other type of order directed at preventing domestic violence, and persistent traffic breaches. Other less obvious past conduct that Justice Mullins considers must be disclosed as it has the potential to be relevant to the admitting body's consideration of the application for admission, include matters such as criminal proceedings which have not resulted in convictions, prior history of depression and a suicide attempt, and an unresolved contempt allegation arising out of litigation conducted personally by the applicant. One other suitability matter that the board must consider is whether a person has the present capacity to carry out the inherent requirements of practice as an Australian legal practitioner. At common law, the principle is as follows. To be a fit and proper person for admission to the legal profession, an applicant must possess the capacity to make the judgments necessary to meet appropriate professional standards in legal practice or otherwise discharge the important and grave responsibilities of being a barrister and solicitor. And that comes from the case of Fruginet and Board of Examiners 2002 VSC 140 per Justice Pagone. Issues that may impact on a person's capacity to practice as a lawyer include physical impairment, mental illness, or addiction. One other suitability matter to note is that English language testing is a capacity requirement for all applicants unless you completed your high school education and your law degree in one of the recognised countries. Those are Australia, England, Scotland, Wales, United States, New Zealand, Canada, or South Africa. For further information, see the Legal Practice Board's website. Once you have completed your law degree and have completed your PLT or are close to having completed it, you can apply for admission. If you're applying for admission before you have finished your PLT, please make sure that you leave at least 5 weeks between the date on which you finish all elements of your PLT, including your work experience and continuing professional education, and your proposed admission date. Although the first step in applying for admission is filing an originating motion in the Supreme Court, an applicant for admission should visit the Becoming a Lawyer admission forms section on the board's website prior to filing their motion paper. Applicants may even like to begin preparing their online admission application form several weeks before they intend to lodge their application, as it will help them to identify the documentation they will be required to lodge as part of their admission application. Please beware, though, that applicants must not submit the admission application form to the board until they have first filed their motion paper at the Supreme Court. The process to admission must be started at least 2 months prior to the anticipated admission ceremony. The first step is to file a pro forma motion paper with the Supreme Court. For information regarding the motion paper, admission ceremony dates, and the latest filing date, please see the Court Procedure Admissions section of the Supreme Court website. Your admission must be moved by an admitted Australian lawyer. The admitted lawyer is not required to hold a current practicing certificate. It is not usual to charge a fee for moving an admission. An admitted lawyer who does not hold a current practicing certificate would potentially be in breach of the Legal Profession Act if they charged a fee for moving the admission. You will be asked to name your moving counsel when you complete your motion paper. If you have trouble finding a moving counsel, please reach out to the college, as one of our lecturers would be honoured to do this. The reason it is recommended that you start your admission application form prior to filing your originating motion with the Supreme Court is that you must complete and submit your admission application form to the board within 2 days of filing your motion paper. There are a number of supporting documents that must be obtained and submitted along with your admission application form. When it comes to your certificates of good fame and character, anyone who supplies a certificate or reference of character to support a person must be informed of any suitability matters being disclosed in the application and must attest to the knowledge of these disclosed suitability matters in their certificate of good fame and character. Because of the privacy implications of disclosures about a person's capacity, it is not necessary that the referee who supplies a certificate of character is aware of any disclosure about the person's capacity, although it may go in the applicant's favour if the referee is aware of all relevant matters. A letter from a treating medical professional confirming that the condition is well managed and stable should be lodged if a capacity matter is disclosed. A national police clearance should be obtained from the WA Police website. Please request that a hard copy certificate is posted to you, as digital police certificates are not accepted for admission purposes. Although spent convictions will not appear on your national police certificate, they must be disclosed. Police certificates or reports must also be obtained from every overseas jurisdiction in which you have resided for more than 2 years after the age of 18 years. It is preferred if transcripts are sent directly to the board by MyEquals or by the university, although the board will currently accept an original. Original documents will be retained on the board's files and will not be returned to the applicant. The board prefers the person providing the 2 certificates of good fame and character to email the completed and signed certificates directly to the board. If an applicant discloses a traffic offence, the board is likely to require them to provide a WA Police certified copy of traffic infringements report for the past 10 years. If you are required to make any disclosures, these are made in a statutory declaration. The statutory declaration must be executed as such, it must be witnessed by an authorised signatory, and the original must be posted to the board. The board might request the applicant to defer their admission if further time is needed to consider eligibility or suitability. An applicant may defer their admission if there are unforeseen delays, such as failing a PLT assessment or illness. If you do defer your admission date, please ensure that you email a stamped copy of your amended motion paper to the board and advise the lawyer who is moving your admission. Once you have established that you have a suitable academic qualification, you have completed your PLT, and that you are a fit and proper person, the Legal Practice Board will issue a compliance certificate at least 7 days before your admission ceremony. This will be filed with the court. A copy will also be provided to you. If the Legal Practice Board is not satisfied that you are eligible or suitable for admission, both you and the court will be issued with an information notice. The Supreme Court will communicate directly with the applicant about the arrangements for the admission ceremony, and queries about the admission ceremony should be directed to the court. You must attend your ceremony in person, and you must be on time. The ceremony will not wait for you. You might like to watch the recording of a previous admission ceremony so you know what to expect. You can find these recordings on the Supreme Court website. What about suitable attire? This is a formal occasion. You are appearing in the Supreme Court. Err on the side of formality. Men should wear a suit, tie and jacket, not jeans. Women should also wear business or corporate attire. We now invite you to ask your questions of our Legal Practice Board of Western Australia attendees. In the meantime, if you have any other queries at all, please don't hesitate to reach out to the College of Law.